Welcome to Channel 17, the Town of Colonie Government Channel.
All right, everyone, thanks for coming. Alex Bunin, he's a federal public defender for the Northern District of New York. They cover 32 counties. The book is called Ordinary Injustice, How America Holds Court. I read a couple of reviews. You know, as a librarian, we got to read all the reviews, but several said this was, one review said this is a very important book. I don't know if it's going to make it to the bestseller list, but it's on my summer reading list. So here's Alex Bunin. He also teaches down at Albany Law, and he's going to tell us about this book.
Thank you, Joe. I'm Alex Bunin, and I'm glad to be here and talk to you today about Ordinary Injustice, How America Holds Court by Amy Bach. Let me repeat that, Ordinary Injustice. As he said, I teach at Albany Law, and a couple weeks ago, there was a panel discussion on wrongful convictions of which the author attended and was a participant, Amy Bach. And the moderator of the panel was the Chief Judge of the New York Court of Appeals, Jonathan Lippman. And twice he introduced her book as Ordinary Justice, which just validates her point that we, the actors in the system, don't always see the problems. It was just, I think, a Freudian slip on his part. But I was glad to be able to review this book. I had not read it when Joe asked me. He gave me two choices of books to review. The other book that he asked whether I would review, and I chose this one, Angel of Death Row, My Life as a Death Penalty Lawyer by Andrea Lyon. I know Andrea Lyon, and maybe for that reason I didn't think it was appropriate for me to review her book. She's an excellent capital defense lawyer. But in looking at books on the criminal justice system, there are many different kinds. There are books by academics, by lawyers, by participants in the system, like victims and defendants. And I thought the impediment for lawyers, especially lawyers who handle well-known cases, of which she did, she represented capital defendants in Illinois and Chicago, is that we lawyers have an attorney-client privilege and confidentiality that we're supposed to carry even beyond the death of the client. And we can be brought up on charges for unethical behavior if we reveal those confidences. So the problem for lawyers who write books is that they can't always tell everything. And so in her book, I know that she has to conflate some events and attribute things to people that didn't say things to get kind of a general truth about what happened. And the same criticism was made a few weeks ago. David Dow is a law professor at University of Houston who's very involved in death penalty litigation in Texas, and he wrote a book called The Death Penalty, and it was reviewed in the New York Times Book Review, and that was one of the criticisms, is that he couldn't always say exactly what happened. Amy Bach is a lawyer, but she approached this work as a journalist, so she didn't have that problem. What she saw, she could report on. Now, Amy Bach is an attorney and a journalist who teaches legal studies at the University of Rochester in Rochester, New York. She's a graduate of Stanford Law School and received the Soros Media Fellowship and a Radcliffe Fellowship. She's published articles on the legal system in The Nation magazine and The American Lawyer. In her introduction to this book, she says, "This book examines how state criminal trial courts regularly permit basic failures of legal process. Her premise is that while the public is aware of some injustices, like wrongful convictions in highly publicized murder cases, those are just symptoms of a systematic problem. Or as she says, it takes a community of legal professionals to let a sleeping lawyer sleep." That sleeping lawyer was Joe Cannon, the late Joe Cannon, he's no longer with us, who practiced in Houston when I practiced in Houston. So I knew Joe Cannon, a terrible lawyer. And judges liked him because he could try a capital case very quickly. He bragged he could pick a jury in one day, which is not good. He famously dozed off during the trial of one of his capital cases, and that's why he's the sleeping lawyer. Bach asserts that although collegiality and collaboration are desired in most activities, of most human activities, our criminal justice system was designed to be adversarial. Therefore, professional alliances are often causes for systemic failure. In other words, if the same lawyers and judges work together all the time, they can build the kind of relationships that make it difficult to point out when a judge or your opponent has done something wrong, especially when it's the type of conduct that's become accepted. So, if it's become standard practice to resolve almost an entire criminal docket by guilty pleas, or to have high bonds set for petty offenses, or to encourage defendants to waive rights, the longer the practice exists, the more accepted it is, and the harder it is for actors within the system to complain about it. The other point she makes is that while there are egregious examples of injustice, and they occur, the persons who cause that injustice often don't recognize it, and they have great difficulty in admitting they made mistakes. In her book, she uses the example of a high-profile Chicago murder case in which two young men were sent away for a very long time for a crime they did not commit. It was later shown, absolutely, they didn't commit it. Some of the misconduct in that case was active. Police did things that was wrong. But a lot of it was passive, just not questioning things. As one former prosecutor says in the book, it's hard to rock the boat when you're in the boat. What I like most about her book is that she tells good stories. I teach trial advocacy at Albany Law School, which means I teach students how to try cases, the procedure of trying cases, but also what's best to do in the courtroom, how to relate their cases to juries and to judges. And what I try to teach the most is about storytelling, which is not fiction. It's just making cohesive, logical arguments with interesting facts and putting them in a way that people appreciate and will listen to. And that's what she does in her book. And there's a lot of nonfiction books that aren't good storytelling, and I'm sure you've run into them. But when an author can take a dense subject and make it interesting, one book I haven't read yet, I want to read Michael Lewis's new book, The Big Short, which is about how Wall Street and the mortgage banks fell apart. I mean, that could be a really dry book if it wasn't written well. But this is the guy that wrote The Blind Side, Liar's Poker. He made bond trading interesting. So a good storyteller can take something difficult, like, criminal trials can be very complicated. Civil trials can be very complicated. So if you learn storytelling, you can make them interesting to your audience. Okay. Now, my perspective in coming to this is I've been a criminal defense lawyer almost 25 years. I began as an attorney in Houston, Texas, in private practice. I became an assistant federal public defender in Beaumont, Texas, after a few years. Beaumont is the first city east on I-10 out of Houston, what we call Houston is known as a drug source city. So we had a lot of drug cases in Beaumont. I was there for a couple years. I was then hired to open the first federal public defender office in the Southern District of Alabama in Mobile, and I was there for approximately 4 years. I then was appointed by the Second Circuit Court of Appeals, which is the Court of Appeals that oversees us here, and also federal districts throughout New York, Vermont, and Connecticut, to open offices here in Northern District of New York and Vermont. Northern District of New York is basically all the way up to the border, as far east as just before Rochester, as far south as almost to Poughkeepsie. So it's big. And in my office, we represent people that are charged in all different kinds of federal cases. Now, I give you that perspective because it's a little different than what the book's about. The book is about failing state criminal justice systems, New York being one. And New York is, one jurisdiction in New York gets a whole chapter in here. There's difference in the sense that federal public defenders make salaries equivalent to the U.S. attorney, and assistant U.S. attorneys Our caseloads are well below the recommended maximums. We have full-time investigators. All the lawyers in my office were experienced criminal trial lawyers before they came to us. So it's kind of what you would hope what you would hope a defense system would be like. It's well funded, and I think we provide a good service. So I'm looking what she's talking about, and she talks about 4 different jurisdictions. One is Greene County, Georgia, which she went to because she was doing a series of articles for The Nation magazine. She devotes her whole first chapter to that. Chapter 1 of the book's called What's a Defense? And this quote comes from an indigent criminal defendant who did not know she was even allowed to contest the charges in her case. That was a question she asked. So Bach begins in Greene County, where she was doing those articles. She describes a system in which an overloaded public defender, prosecutor, and judge resolve each day's criminal docket by a triage of plea bargaining. The public defender typically saw his clients only immediately before appearing in court. He would then tell them what the deal he had worked out for them, and if they didn't want it, they'd just reset the case. Terrible system. So one day, Bach goes to Greene County Court accompanied by a gentleman named Stephen Bright, and I'm going to just read to you from the book so you get a flavor of the book, and also she tells it better than I could tell it to you. I know Stephen Bright too. He's a friend of mine. Stephen Bright, the president and senior counsel of the Southern Center for Human Rights in Atlanta, had decided in the mid-1990s that Georgia's indigent defense system was so bad that he and his organization were going to keep challenging it until it was brought into line with the ideals of American justice. Bright, in his 50s, had made a career of championing unpopular causes. He became the director of the struggling Southern Center in 1982 and has worked without pay in defense of people facing the death penalty and on litigation to improve jail and prison conditions throughout the South. The organization has 11 attorneys and an equal number of investigators, and a stream of students and volunteers. They talk a little bit about his hard work and give a little bit more example about him. But what's interesting is he goes with her to court. It says, until the state made proper changes, Bright planned to expose and root out bad defense systems, one by observing various courts in action and filing a series of lawsuits claiming violations of the state and federal constitution. I learned about Greene County's problems from a series of phone calls with advocates in Atlanta, and when I told Bright it was one of the courts I was considering looking at, he said he'd never been. I asked him to join me so he could get his perspective on how this court matched up with others he'd seen. Even though he had appeared on Nightline, on the radio, and various newspapers, articles, legal professionals knew him by name, but not always by face. In Greene County, Bright slipped into Judge Hulain George's courtroom unnoticed. He sat with a yellow pad at his lap and at the end of the first row, near a few other lawyers who had cases that day. Bright believes that the change begins on the ground, in the courtroom, and he doesn't hesitate to speak his mind, much to the annoyance of judges who feel he lectures them when he should be the other way around. As the day went on, the proceedings in Greene County became harder to hear. The less people could understand, the more frustrated, bored, and restless the audience became. Spectators shifted loudly in their seats. They whispered. I sat a few people away from Bright attempting to take notes. The people couldn't hear a thing, and Bright sensed their frustration. He leaned over and whispered, "Why don't you go and ask the judge to speak up?" I laughed. I considered myself an observer and wanted to be inconspicuous as possible. I was also embarrassed to make a ruckus. This was court, after all. I went back to straining to follow. Suddenly, Bright was on his feet. "Your Honor," he said in a deep, loud voice, "this is a public hearing, and there are people who want to listen to what's going on. So if you don't mind speaking up, that would be much appreciated." And that's just how he'd say it. Judge George looked like she'd been slapped. Bright didn't seem like a commanding man, more like a lanky Kentucky farm boy he had been growing up. He had a wholesome face and full red hair parted to the side. His clothes didn't match his pedigree. He teaches at Harvard and Yale law schools in his free time, but prides himself on buying $80 suits on the road. A deadening, somber silence followed his interruption. "Excuse me, could you please come before me? I would like to talk to you," Judge George said. "No, ma'am, that's fine. I don't need to appear before you. I will stay right here. I'm just an observer. I would just appreciate it if you would speak up. Thank you, ma'am." Bright sat down, refusing to budge. "Sir, I order you to come stand before me," Judge George said. Bright climbed his way over the packed row with gravitational force, whipping himself around to play to the audience. He took control of the courtroom. Your Honor, my name is Steve Bright, and I am a lawyer visiting court here today from Atlanta. I am here to listen to this public hearing. People have a right to hear what's going on. We're all here missing work, having left our children in the care of others, and we want to hear what's going on in court today. You are denying us our right to listen to a public hearing, so if you wouldn't mind, please speak up. The exhausted, twitchy crowd was now focused. Someone started to clap, and soon the entire courtroom was applauding with cries of "Amen," and "That's right," and "We can't hear anything," and "Thank you, sir." "I have this viral junk in my throat," Judge George said, and she seemed tired, alarmed too. For the rest of the day, the judge used a microphone and would tap it regularly, asking, "Can everyone hear? I just want to make sure. There seems to be a lot of interest here today." In a court where people had grown accustomed to being ignored, merely asking the judge to speak louder was blasphemously glorious. It shook things up so that someone in the audience shouted out, "We can't hear you," at Searcy. Robert Searcy is the public defender, who now was also taking heat. Searcy, tensely flipping through his notes, had to respond to the audience, most of whom were his clients. "Can you hear me now?" he said, facing the crowd. "No," the people shouted. Judge George clapped her hands together. She used to teach school, she told the crowd, and couldn't stand noise. Bright had become a celebrity. In the breaks, people patted him on the shoulder, shook his hand in gratitude. "I got something to tell you," said a man in denim overalls, and then he launched into the complexities of his case. "Come talk to me next," said a woman, hitting Bright on the arm. So that's a good, in fact, I did talk to Amy Bach. I didn't know her, but I got to know her from that time she came to the law school, and I called her the other day. She said, "Yeah, that would be a good passage to read." She really likes that part. And so what's interesting about the Greene County scenario, which is chapter 1, is Bach compares it to a successful public defender office in another Georgia county where the culture remained adversarial. And this is just too cozy. The judge and the prosecutor, they just got used to working out all the cases every day. At the end, the Greene County PD, this guy Searcy, goes to work for the other county. And he becomes a much better lawyer, an effective lawyer. There's nothing wrong with him personally. He just got caught up in a system where he just kind of gave in. For any of you that may have noticed, this is a very good week for this book to be out. New York Court of Appeals heard a case Tuesday about the systemic constitutionality of New York's indigent appointment system. And it's case called Harrell Herring versus State of New York was argued in the Court of Appeals on Tuesday. An amicus brief was filed by 4 bar associations, 4 New York law schools, and 40 law professors, all arguing that the current system is not adequate. And if you read the metropolitan section of Sunday's New York Times, you would have heard a great deal about the case, including the lead plaintiff. Kimberly Harrell Herring was a young mother accused of trying to smuggle a small amount of marijuana into a New York prison. She was represented by Washington County Public Defender. Washington County awarded its public defender contract to the low bidder. And as she points out in the book, that's one of the worst ways to start a public defender, is to have a contract system, because it goes to the low bidder and they always underestimate how much work they'll have to do, so they end up doing very little work. The county failed to learn that the attorney they selected had been reprimanded by the state bar and suffered from depression. Despite the fact that a lawyer from the New York State Defenders Association explained to the public defender why the offense that she was charged with was not a felony, and that was later upheld by the Court of Appeals, the public defender compelled Harrell Herring to plead guilty to a felony, which was a huge problem for her, not only because of the conviction, but she worked in a nursing home and would cause her to lose her job. Only after pro bono representation by a large New York City firm was the conviction overturned and she able to get her job back. But, I mean, here we are, upstate New York, and it's just like Greene County, Georgia. In the case before the Court of Appeals, the amicus brief argued systemic deficiencies deprive indigent accused of assistance of counsel at critical stages of the adversarial process and create a high probability that they will be denied meaningful and effective representation. This is the exact premise of this book. That's what this book's about. The amicus brief continued, these deficiencies include routine delay in appointment of counsel, absence of counsel at arraignment, counsel who do not accept calls or voicemail or respond to letters, counsel who cannot or do not meet with clients except immediately prior to court appearances, if at all. The intermediate court below had found that challenges to ineffective assistance of counsel can only be made in individual cases after the person is convicted. Well, that's a little late. There's a saying that you can beat the rap, but you can't beat the ride. I didn't know what that meant until I became a lawyer. I started in Houston. I worked for a very famous, well-known criminal defense lawyer there, a guy named Richard Racehorse Haynes. They ended up making TV miniseries about some of his cases. But when they found out they passed the bar, they said, here's your first case. And it was just a simple assault case that was in city court, and down there you can actually have a jury trial in city court, a 6-person jury. So the case was about my client was this young man who had taken his girlfriend into a bar in downtown Houston, and they were just young kids, and they didn't really realize where they were. They were in a bar called Fuzzy's. And if they thought about it a little more, they would have figured out it was an after-hour police hangout. And so they started playing pool with their new friends, and then after a while, somebody put a hand on the girl. The guy, I don't know if he took a swing at him, but he certainly acted like he was. All of a sudden, he's on the floor in handcuffs and off to, Houston jail to spend the night. And I think they lost him for a while in the system, so he was probably spent more than a whole night. A couple weeks later, I've investigated the case. I'm ready to cross-examine people. We go to court. It's a city court, so it's one of these big courts where there's 100 cases on the docket. A lot of them are just traffic tickets and stuff like that. And we're sitting there, and finally about 10 a.m., the courtroom is just about empty, and I go up to the prosecutor and say, well, what about this case? He says, wait a minute. He goes back, makes a couple phone calls, comes out, hands a piece of paper to the judge, case dismissed. Oh, he spent a couple. Well, he got out on bond, but they can lose you for a while, So he spent maybe more than 24 hours in jail, and that is the meaning of that phrase. You can beat the rat, but you can't beat the ride. There's all these bad things that can happen to you in the system just by being accused, and they make a good point of that in the New York case in their brief. They say the deficiencies not only affect determination of guilt or innocence of the indigent accused, but can cause severe and unremedied collateral consequences such as incarceration, loss of employment, or contract with family at critical times, or other harms. And that's the point she makes in her book. I mean, this is an excellent storytelling about those things.
So would the record be like yours?
This person never had a record. I mean, I guess there was an arrest, but it resulted in a dismissed case, so they don't.
So they don't.
Yeah, they don't. He doesn't have a record. Now, chapter 2 of this book is about Troy, New York. It's called A Troy Champion, former Judge Henry Bauer. Judge Bauer was removed from the bench by the New York State Commission on Judicial Conduct. The basis of his removal were charges that he set extremely high bonds in petty cases, refused to appoint counsel to some defendants, and even found defendants guilty without their knowledge or participation. And maybe you followed this case. It would have been about 2002 or 3 or around that time. And what's interesting about the case, and I don't know Hank Bauer. I don't practice in those courts, and I didn't. And apparently he's very well liked. And even lawyers who I know were interviewed in this book and said, oh, yeah, he was a good guy. But the problem is, if you're denying people their rights, it doesn't really matter how nice you are. There's lots of nice judges who will follow form but not substance. So, I think it's very interesting because we're from this area, and I think you would enjoy reading that part of the book. But it just shows, there's no area of the country where it's just, it's a problem there. We don't have these problems. It's a problem everywhere. Chapter 3 of the book's called Miss Wigg's List. It's about Quitman County, Mississippi, where she found many persons initially charged with crimes that were never indicted or pursued. And I think the point of this is that most of these cases were domestic violence cases, and they simply weren't prosecuted. Somebody would say, my boyfriend beat me up. cases like that, and they would be charged, and then the case would just go away somewhere. So it's kind of a different look at injustice in the system, in that these victims were never addressed in any way, and I think that's important. Although, other than domestic violence cases, I don't think we have a lack of prosecutions in this country. So I'm not as clear on that one as some of the other things in the book. But I think she makes a good, important point that there's a lot of discretion about prosecutors, what the charges they can bring, whether they're political considerations. I think it's an important chapter in the book. Chapter 4 is, again, it's about the two young men in Chicago who were wrongly convicted of a highly publicized rape and murder of a young girl. They spent many years in prison. It drove one of them to mental illness. The case would not have even been reviewed, but not for the lead prosecutor many years later had some lingering questions, and by raising those questions and causing others to reinvestigate, he helped right a wrong. But then he only received animosity from his fellow former prosecutors and police. They hate him now. I was going to read just this one little section about what he says years later. His name was Thomas Breen. It says, throughout the Dotson case, Breen had been running a weekly self-help meeting in his neighborhood at a halfway house for boys. One evening, as he left the building, he caught a glimpse of a man walking up the stairs. Breen realized he was one of the defendants in the Pontiac prison riot case, a man he had charged with murder and whom he had sought the death penalty. "How are you, Ben?" Breen asked calmly. He threw his arms around the man and wished him well. Over the years, he'd encountered several other defendants in the riot case. Once he realized that a clerk in the public defender's office at a juvenile court had also been a defendant he had tried to put to death. Breen found it significant that he kept running into these men. "I'm not a religious nut. I'm not particularly gung-ho about the death penalty, but 4 people in my neighborhood that I prosecuted in a capital murder case, he had called them the worst people in the world, and now they walked in the same circles as he did. I actually met them on the street. They were people to me, people who might be able to get better. As a child, he had been taught to see people as either good or bad. Now he was trying to cultivate a more nuanced approach. When you prosecute someone in a case, you take their worst act on their worst day and judge them by that," he said. "It was difficult when you see them on better days and they are doing right thing." So, there's just many good nuanced views about, people seeing the other side of issues. I mean, we have an adversarial system, and I think it's a good system, because if it goes right, if everybody's working their hardest, the truth should be somewhere in the middle. But when one side falls down, or criminal defendants' rights are denied and something stops working, bad things can happen. And so what this book is looking at is not only when people drop the ball, but also the injustices that are done when rights are not taken into account. I have a few more things I can say, but I thought if you have questions. Yes, sir.
What's the main takeaway that you revealed to yourself once you finished the book?
Well, a lot of these things I sensed myself. I mean, because I've been in the criminal justice system so long, I think it validated a lot of what I already believe. But I think for someone who hasn't been in the system, this is a real kind of eye-opening book, and really documents well some of the things that people like me know but don't always want to admit. I mean, you get too close to other people in the system and you can drop your guard. Over the years, I guess maybe because I don't play golf. I don't hang out with judges or prosecutors. I don't socialize with them, but I'm a very antisocial person. I read books. So maybe that's benefited me in that I have never gotten kind of a clubby feel with with other members of the court. But if you were a public defender in a small county and you were completely overloaded like this Surrency guy was, who apparently is not a bad guy. I mean, he ended up being a good lawyer. But he's completely overloaded. His only contact is with the judge and the prosecutor, and they're just trying to work out their cases. And they think they're doing a great job because they're resolving all these cases. But it's not so great for the people. I remember when I started practice in Houston, and I would get appointments, and you'd go to the misdemeanor courts, and they'd appoint you to a case, and someone had spent the night in jail, maybe a few nights in jail, and it's a misdemeanor. So they'll say, okay, time served. That's the offer. If he pleads guilty today, he gets time served. And the person would say, well, you know, I really didn't do that, but yeah, we can get a trial in 30 days. Okay, well, no, I want to get out now. I want to plead guilty. I mean, that's how the system works, and it is not right.
Is everyone offered, or people that need it, are they all offered the public defender?
If you are facing a charge in which you could spend more than 6 months, you have a constitutional right to a lawyer. Now, as you see from the Troy case, sometimes that's ignored if the judge could drop the ball. But the Supreme Court of the United States has been very adamant, even in recent cases, saying, no, you must appoint counsel when they show up on their first appearance in court. You can't just wait 6 months and say, oh, you're going to have a trial? Okay, now we'll give you a lawyer. So the law is clear. The law is clear.
But general or just New York State?
No, general. It's a constitutional right to have appointment of counsel. Now, if you're facing a petty offense, like in New York they call them violations, where the most you could pay is a fine, then you would not necessarily be appointed counsel. Like you went to a town court. A lot of these town courts, you just go and they'll say, you can go back and talk to the prosecutor, and you do, and you don't necessarily have a right to appoint. But if you're facing like more than 6 months in jail, then they have to. You have a right to counsel, and you should. The person should complain, and if a judge isn't doing it regularly, they should be investigated. Yeah.
Is there a difference between a misdemeanor and a felony to be given a lawyer?
Well, all felonies you would have to have a lawyer. Misdemeanors, again, if the punishment is more than 6 months in jail, then you would be guaranteed a right to counsel. And some states have statutes that just say, for any case. That's the Constitution is the minimum. And then states, if they want to enact statutes that give more rights, they can do that. And so some states would say, well, you have a right to counsel even in a petty offense.
What could remedy some of these situations?
Well, yeah, and legislatures sitting down and figuring out that they're being penny wise and pound foolish by underfunding their criminal defense systems. In the argument the other day before the Court of Appeals, one of the judges says to the lawyer arguing to tear the system down is, so you want us to write a blank check? And really, it's not for the courts to design indigent defense systems. All the courts can say is, you do not have an adequate one. It is not constitutionally permissible. It's the legislature that needs to get their act together and say, we're wasting a lot of money on wrongful convictions. You got to pay people money when you put them in jail for 20 years and they get out. When you have more appeals, you got more litigation. Having a poor system is not necessarily cost effective. So it really puts the onus on the legislature. I lived in Texas when a federal judge took over our entire prison system. William Wayne Justice in East Texas said, this system is unconstitutional. I'm running it now. So courts can step in, but it's really a function of the legislation to create good criminal defense systems, and they shouldn't be contract systems. They shouldn't. I don't even really support electing defenders. I think our system and the federal system, we're within the courts, so we're funded by the Administrative Office of U.S. Courts. Panels of judges oversee us. The Committee of Defender Services of judges oversee us. It goes all the way up to the U.S. Supreme Court. And so we're kind of sheltered in that they understand what we do and they kind of appreciate it and they make sure we're properly funded. But when it's up to some local lawyer getting a bid from the county, that's when things really can go wrong. So.
Does she do any quantitative analysis in terms of the 50 states and the territories in terms of which, for instance, if legislatures are vested, as you suggest, with the responsibility to make the necessary changes, does she do any ranking of the states? I mean, considering New York State's legislature, I wouldn't be holding my breath for them to do much of anything functional for.
No, and I think that's true most places. This only comes up when everything else is going down the drain too. But what she does do, I think she feels that it's a little beyond what she was capable of doing by herself. What she does do is call for some type of more methodical analysis of what can we measure as being a good system, which is difficult to do, but there is really no measurement now. There are standards. The ABA has standards for indigent defense, which not everybody follows, like maximum caseloads. There's plenty of states that are out of line with the ABA guidelines. So there are recommendations in place and things that can be done, but I don't think there's been a comprehensive. Now there's some folks, like there's a guy named Robert Spangenberg who assessed the New York system and has done it in other places, and he is paid as a consultant to come in and assess indigent defense. So there have been reports done about individual states, and I guess you could put all those together and look at that. But, yeah.
The 6-month threshold for appointment, does, for instance, if a conviction were to result in a X period to Y period internment, is it the minimum that a person,
well,
I mean, conceivably,
if you didn't get jail time, it's kind of like no harm, no foul. But if the potential sentence is 180 days, then you should be appointed counsel. Yeah.
Minimally, okay.
Yeah, because you can't really look at it after the fact, but you should have that protection of counsel if you could go to prison or jail.
Can they appeal a case like that?
For denial of counsel, sure. Yeah, and that's one of the protections the Supreme Court is pretty strong on. Even in our very conservative Supreme Court, they've had a number of decisions in the last couple of years that right to counsel is absolutely, you don't need to show prejudice. You just, if you didn't get counsel, your conviction should be overturned.
Does the author address the issue of judge selection, direct election versus the Missouri system, which is in place in many places in the country?
She doesn't. She begins with the premise that we have an adversarial system, but she doesn't really say, what's the best way to have. I mean, she's really looking at indigent defense, so she doesn't really look at like what's the best way to pick judges, what's the best way for prosecutorial discretion to be used. She's more focused on the system of indigent defense. I know what you're talking about. You're saying that some places have elected judges. New York does. Texas did where I was, which is a terrible system because nobody knows who these people are. One time they elected the Supreme Court. Maybe he didn't get elected, but he almost got elected. A guy named Gene Kelly. All right, Gene Kelly. They thought, well, Gene Kelly's like the dancer. We had a guy. Oh, it was even worse. We had a pretty good senator way back when, Senator Hightower, and later. A guy named Hightower runs for Texas Supreme Court and gets elected. Then he gets convicted. I mean, it's all name recognition because nobody knows, the qualifications for a judge. And I'm not saying a completely appointed system is great necessarily either because it's very political too. I mean, our federal judges are all appointed. They get quite a bit of scrutiny, but, it's not always perfect. Yeah.
Well, the Missouri system entails a judge running after he's selected by the bar and then appointed to the political. He has to run against his record periodically. He doesn't run against competition, but he runs against. And I've seen, inept and crooked judges removed by that system.
It could be. I mean, you still end up with elections, and incumbents are really hard to remove. I mean, in the New York system, people really don't run for judge that much. They get picked, and then they got that job as long as they want it, pretty much.
Was there any historical mention, context of the Miranda decision back a few decades back?
The which decision?
Miranda?
Miranda in the book?
Any reference to that?
Well, there's in the Chicago story. There's a great deal of talk about how the defendants were interrogated, and that goes kind of beyond Miranda. Miranda is what they call a prophylactic measure. Police love Miranda because they get to read that little card that you see them on TV, and that protects everything. And then, of course, defendants love to talk. They don't care. They don't even listen to what's written on the card. So once they've read the Miranda, and then they can get the guy to waive the Miranda and talk to them, they pretty much protected that statement from attack later. So when Miranda came up again a few years back before the Supreme Court, police organizations were all for Miranda. But there are other ways to coerce statements without even in compliance with Miranda. So she talks about custodial interrogation, and especially in the Chicago case where it was really bad. Yeah.
So if you read your Miranda rights and then you refuse to talk and request an attorney, you just don't volunteer any information,
right.
They handcuff you, take you to the jail.
Well, that could be a consequence. I mean, if they have a basis to arrest you, meaning probable cause to arrest you, yes, but you may be saving yourself a lot of misery later most people think they can talk their way out of anything. And it's absolutely wrong. And anything you say, you may not admit to the conduct, but you may put yourself in a place where they go, okay, now we know that person was there. That's one more link in the chain.
Oh, they even try to read your body language.
Yeah. So
how long would you be at the county jail before you would be given counsel?
It varies from jurisdiction to jurisdiction. In federal court, if you're arrested over here, and you're going to be brought to court that day. Or if it's like a weekend within 24 hours. Most courts have at least a 48-hour minimum. Yeah, a minimum. But if it's a day of court business, you're likely to be brought before a judge as soon as court can be held in most jurisdictions.
And then
the judge would set bond. Yeah, or if you're entitled to counsel, they would appoint counsel. But they would certainly take up the issue of conditions of release or bond right away.
But if you're indigent, you're probably not going to be able to.
It depends. It depends on the system. There are ability, like in federal court and a lot of states and jurisdictions have adopted this, we have conditions of release, which don't necessarily have regard to money. They might be curfew, or you report to a pretrial services officer, or things like short of detention. Yes, in jurisdictions that rely heavily on surety bonds, money is a problem.
Like Florida?
Florida, Texas, yeah. They're very ingrained. Ma'am, you got a question?
I was asked to be on the jury, and they say that you're a jury of your peers. Well, the poor guy that was up for whatever, I don't even remember, I didn't think he was my peer, and I'm sure he didn't think the other way.
Yes.
Now, how does that work?
Well,
What's the definition of peer?
yeah, it doesn't. On a person-to-person basis, you're not going to be able to challenge someone just because they come from a different background. There are systemic challenges. If, for instance, if a court system was shown to have only selecting people from like one part of the district, and all those people were white, and the people from the black part of the district never got selected, then you'd have some kind of systemic challenge. Otherwise, it's going to have to be because the lawyers tried to remove someone for their race or gender or ethnic background, then that might be an issue. But no, it's never going to be pure. I used to also have Vermont as my district. It's now a separate district, but you don't get minority jurors there. I mean, everybody's white, and yet defendants may be from somewhere else, and they be of color, and they're not going to get people that look like them. I used to practice in Beaumont, Texas, and because there were a lot of drug cases, most of the defendants I represented were African American. And in jury selection there, we had one judge, at the time he was 86, and he had been, at one time he was the only judge in the Eastern District of Texas. He was appointed by President Eisenhower, and he had his own way of jury selection. Everybody stood up, they gave their name, they gave their spouse's name, they said where they worked, where they lived, and they sat down, and you made your strikes from that. And the only thing I could go on is if they said they were from Vidor, Texas, which was known as the home of the Klan, I struck them. I didn't want them. So you have to, sometimes the less information you have, the more you end up using your own stereotypes in selecting juries. But you don't get a jury of your peers in the pure sense, no. Yes, ma'am.
My husband was a village judge for several years. As soon as they arrested somebody, they had to come get him immediately. Why? I mean, in a city, you don't have that happen.
Well, in New York City, they have courts running all the time. So they,
24 hours.
yeah, they have
Night court.
yeah. And in some jurisdictions, they don't necessarily have to be immediately before a magistrate judge. And you know, they probably wouldn't get to court right away in Houston, at least till the next day.
But he was
Yeah.
court no matter what time of the day.
Well, that's true. And I know, for instance, I live in Bethlehem, and I know Ryan Donovan was a judge there, and yeah, he gets called. So it depends on the jurisdiction. But our federal magistrate judges, they don't get up in the middle of the night. No. Those people, they come to court the next day. Yes.
So what sort of cases do you do in your position?
You know, it really depends on what district you're in. In this district, you know, we have a number of urban areas. We got Albany, Schenectady, Troy, Binghamton, Utica, Syracuse, Plattsburgh. And so you'll get, you know, kind of inner city crimes, drug crimes, gun crimes, even some crimes of violence. Sometimes we get bank robberies. But because we have a huge international border, we also get a lot of immigration crimes. So people that are arrested entering the United States, either non-citizens attempting to enter. Usually, if they're just non-citizens attempting to enter the first time, it's just a misdemeanor, and they may or may not prosecute. A lot of times we get people who have been deported before, are returning, and have been convicted of crimes before, and they're facing pretty serious charges. Also, people with false documents are charged at the border. So immigration crimes is a good part of our docket. Drugs, fraud.
Why would they go to the federal court rather than the state court?
Well, sometimes they can go either way. Somebody was asking me today, I got an email from a defender in Philadelphia. He said, our friend's son was stopped at Champlain. They were coming back, I guess, from Canada, and somebody had a little bit of marijuana in the car. And they took him to town court. And they said he pled to a violation. What does that mean? And so, what she didn't understand was, why wasn't the federal government involved? And I said, well, they just don't do that. I mean, it's too little. So they would turn it over to the state people. So sometimes it's priorities. Sometimes you have these state federal drug task forces who say, all right, you get that case and you get that case. But they could have been prosecuted in either jurisdiction. I tried a federal capital case in Vermont that could have been brought in it could have been brought in state court in Vermont, federal court in Vermont. Part of the crime occurred in the Southern District of New York, so it could have been brought in New York State in that county, or in the Southern District of New York. So there was just, you know, a decision made by the authorities where they were going to bring that case.
So which authorities make that decision?
It's a combination. And the federal government ultimately is the Attorney General of the United States, who's now Eric Holder, but there's also local interaction.
So it's kind of like a powwow, and then
Yeah.
the decision is made. Okay.
Yeah, there's a lot of politics involved. If it's a highly publicized case, like in that case, certainly the state county, I forget what county, whatever county, Poughkeepsie, that's not Ulster. Yeah. They had already tried in a New York capital case before that practically bankrupted them. They wanted nothing to do with that. So there's all kinds of reasons that go into it.
Do you cover New York City and Long Island, or just
No,
jurisdiction?
we have 4 districts in New York: east, west, south, north. I have the Northern District in New York. The Western District would be Rochester, Buffalo. The Eastern District of New York is Long Island, Queens, Brooklyn. That's pretty much it. And then the Southern District is Manhattan, Staten Island. No, that's not right. Staten Island is the Eastern District. Manhattan, Bronx, and then everything up. White Plains, everything up to Poughkeepsie.
Westchester.
That's Southern. So we have 94 federal districts in the country. All but 2 are covered by public federal public defenders in some way. The two counties that are left, I think 2 districts that are left, one is in Kentucky and the one in southern Georgia. I'm not sure why they won't do it, but so there is some form of, and then when we have conflicts, which we often do in a multi-defendant case, we can only represent one defendant. We have a panel of lawyers from the private bar that are assigned cases to, and we oversee and make sure they get trained and are of quality to do that.
Are they then paid through?
Mm-hmm.
Okay.
They're paid through the courts. The court signs off on their voucher.
Okay.
I think now, hourly, they're making at least $125 an hour, which is okay. I mean, they're not getting rich doing it, but you know, New York pays some insignificant amount of money for state defense. It's one of the lowest ones. So, in that sense. Let me just point out on the back, and Joe mentioned this, the reviews of this book. I mean, this woman was not known as an author, and yet here's Anthony Lewis, the author of Gideon's Trumpet, saying, "More than anything else I've read, Ordinary Injustice tells us what actually happens in a prosecutorial world. That reality is painfully different than the romantic picture of constitutional rights triumphant that I helped to paint in Gideon's Trumpet. It is a fascinating and essential book." Doris Kearns Goodwin, Brian Stevenson, who's a really great lawyer I know from Alabama, Steve Brill, founder of Court TV, okay, that's right, Samantha Power, who's a professor at Harvard, and another author who I also recommend, Steve Bagheera, who's the author of Courtroom 302, A Year in the Scenes of an American Criminal Courthouse. That's another really good book by a journalist, it's now in paperback, about a criminal justice. It's about a year in the Chicago courtroom. And I assigned that book, it's kind of a secondary reading for my class, because it's another good instance of a journalist coming in and really kind of looking at the broad picture, as opposed to lawyers saying, "Gee, look what a great job I did," and or you know, victims or defendants who have their own kind of bias in that, you know, this terrible thing happened to me, see it from my perspective. They tend to be a lot more objective. So I recommend this book very much.
Thank you.
Okay, thank you.